One way an institution will own copyright is where works are created within employment. My colleague Lynn McHugh will now take us through some of the issues relating to such works.
Good afternoon. In this section, we shall consider the implications of Section 11.2 of the Copyright Designs and Patents Act 1988. Copyright in works created in the course of employment. Section 11 of the Act relates to ownership rights in copyright, and Section 11.2 deals specifically with copyright ownership in works created within the course of employment. The provisions of Section 11.2 are as follows. Where a literary, dramatic, musical or artistic work, or a film, is made by an employee in the course of his employment, his employer is the first owner of any copyright in the work, subject to any agreement to the contrary. Under the terms of Section 11.2, employers acquire ownership of intellectual property rights relating to any works created by their employee which the employee is required to create under the terms of their contract of employment. It is worth noting that the works created by the employee in their own time, insofar as they relate to their employment, may also be deemed the property of the employer. The case of Missing Link Software versus McGee demonstrates this fact, where the court held that copyright in a software program written by an employee in his own time using his own resources was in fact made in the scope of employment. The nature of the works fell within the scope of the task that Mr. McGee was employed to do. It is also vitally important to consider the nature of the contract that the employee is employed under. For example, the employee may be self-employed or freelance, and it may not be clear if an employer-employee relationship exists for copyright ownership purposes. If the individual is employed under a contract of service forming the traditional employer-employee relationship, then it is fair to say that this relationship shall be bound by the terms of Section 11.2. If not, and the employee is employed under a contract for service by the employer, then there is no automatic right of ownership preserved under Section 11.2. For example, it is likely that a guest lecturer speaking at a one-off event is not an employee and would retain the copyright in their work. Again, this is subject to any agreement to the contrary. If the institution wanted to reuse this work, then they would need permission from the speaker. There are various factors to consider in order to determine whether the employee is employed under a contract of service or a contract for service. These factors include whether or not the employer controls the terms and conditions of work, and whether or not the employer controls holiday pay, sick pay and pension rights. If so, this is likely to constitute a contract of service. The individual would be an employee and the conditions of Section 11.2 likely to apply. For the avoidance of doubt, it is important that employees who wish to maintain ownership rights of work created within their own time should ensure that there is an express term contained within their contract of employment to provide for this. Copyright ownership in FE and HE. The beneficiaries of copyright ownership in FE and HE can be its staff, outside contractors or students, as well as the institution itself. Research data, teaching materials, lecture notes may all be works which enjoy copyright protection. Indeed, ownership in copyright with regard to teaching material is fast becoming an issue for learning institutions seeking to protect their interests in relation to IP issues. Universities, as employers, are granted certain rights over IP created by their employees and remain the owner of copyright works created by a member of staff within the scope of employment. However, with regards to work created by their students, copyright ownership shall rest with the student. Institutions seeking to clarify copyright ownership should address this issue by setting out an intellectual property ownership policy. The policy can set out and clearly define ownership of IP, whilst detailing the expectations and rights of staff and students regarding IP issues. Such a policy will be subject to the test of fairness. Ownership of copyright by staff. As discussed earlier, we know that copyright ownership of works created by FE and HE staff is principally dependent on whether the creation of the work was within the scope of his or her job specification. However, it is worth noting that many FE and HE institutions have expressly or impliedly waived their copyright in materials produced out with the remit of the academic's job specification. The rationale for this may be that by allowing the academic to retain copyright in the work, he or she is encouraged to produce more material, thus raising the profile of the institution. So, for example, one of the common requirements currently included in the job specification of most academic staff is to raise the research profile of FE or HE institutions through publications in journals. It is also worth pointing out that some academics hand over their copyright to academic journals and that the institutions pay for subscription to these journals. It may well be the case in law that these journals may contain articles in which, as an employer, the institution already owns copyright, and which, as an employee, the academic was not in a position to hand over. In the case of collaborative research, partnership between FE and HE institutions and outside partner copyright ownership can be held jointly. It is often the case that an agreement regulates this partnership. This agreement also should include agreement as to ownership of copyright and other IPR. The Copyright Design and Patents Act 1988 provides that the owner of copyright works created within the course of employment vests with the employer, unless there is an agreement to the contrary. However, there are certain grey areas with regard to what constitutes the employer-employee relationship and what work is deemed to fall within the scope of employment. Case law on this subject highlights certain factors that the courts will consider in order to ascertain who owns the copyright of a particular work, with each case being made on a case-by-case basis. Best practice would suggest that institutions adopt an IP policy, clearly setting out ownership rights.
Thanks for that, Lynn. So we now know it's important for an institution to establish who has created the materials. Is this an employee, for example, and under what circumstances? If this is deemed to be within the course of employment and there is no agreement to the contrary, then the employer will own copyright and they will have control over the subsequent use of that material.